Okay, so why don't we get started? Maybe people will keep trickling in. If you're on this side, I invite you to come join us on the other side if you like. I don't think we're going to be a super huge group. Thank you all for joining us for the latest installment of the LPE Night School, LPE New School, New School's LPE Night School at the New School. This is a regular series of talks about legal topics from an LPE perspective, but targeted at a non-lawyer audience. So if you're a lawyer, we hope you'll find the talk interesting, but our target is, you guys, does that make it better? Right. But the hope or expectation is that this should be of interest to non-lawyers as well. If you're joining us online, thank you for joining us. Earlier notes suggested you can hear us. If at any time you can't hear us, just put a note in the chat and we'll talk more loudly. My name is Noah Rosenblum. I'm an assistant professor of law at the NYU School of Law and one of the organizers of LPE NYC, and I'll be moderating tonight's conversation. Before we get started, just a couple of quick thank yous. Thank you to Sandipto Dasgupta, our contact here at the New School and co-organizer, without whom we would not be here. Thank you to Corinne Blaylock, who makes everything LPE happen, including this event. And a special thank you to our three fantastic panelists. We really couldn't ask for a better group of scholars, organizers, activists to talk with us today about courts. We've called today's panel either the law and political economy of the courts or courts, the good, the bad, and the political economy. Our hope over the next hour or so is to spend some time thinking together about the role of courts in constructing the political economy we live with today and how we could take action to try to make them and it better. The main focus is going to be on the courts that affect us most that we don't hear about, not the Supreme Court of the United States, probably not too much on the federal courts, but more about local courts, state courts, city courts, family courts, those institutions. We're joined today by Jocelyn Simonson, professor of law and associate dean in Brooklyn Law School, and the author most recently of Radical Acts of Justice, How Ordinary People Are Dismantling Mass Incarceration, which focuses on collective resistance within criminal courthouses. It's a fantastic book. We also have Tarek Ismail, an associate professor of law at CUNY Law School, the co-director of the Family Law Practice Clinic, and counsel to Creating Law Enforcement Accountability and Responsibility Project, the CLEAR Project. And finally, we're joined by Pete Martin, the director of the Judicial Accountability Project at the Center for Community Alternatives. I'm obligated to say an alumnus of NYU Law, woohoo! And the lead organizer behind the Court New York Deserves campaign, which was instrumental in leading to the defeat of Kathy Hochul's nominee for the chief judgeship, Hector LaSalle. So I've given very short introductions, but to start things off, I thought I would invite each of you to just say maybe a little bit more about your involvement in or organizing work with related to courts, court systems, particularly those other than the Supreme Court and the federal courts. And I thought that perhaps in talking about that, you might say a word about how your experience informs the way you think about courts now.
Great, how should we start?
Why don't, Jocelyn, if you don't mind, can we start with you?
Yes, I'd be happy to. Hi, everybody, good evening. My experience with courts, started probably when I was a public defender in the Bronx. I did that for 5 years. And as I did that, this was at the height of stop and frisk in New York City, I spent a lot of my days in absolutely packed courtrooms. So these are courtrooms where the audience was filled with people of color, almost entirely Black and Latinx New Yorkers, all of whom were poor and could not afford lawyers, or were family members or loved ones of people who were being accused of crimes, who sat in these courtrooms all day long waiting for a case to be called. And the truth about the criminal legal system is that it's not a system of trials. So they weren't sitting there watching arguments made in front of juries. Instead, they were sitting there waiting for a case to be called for a really quick guilty plea, a really quick dismissal, or most often an adjournment to another court date. Or perhaps they were there waiting for a loved one to come out in handcuffs for 30 seconds in front of a judge. And I love being a public defender. There was a lot of advocacy and subset of things to do, but they weren't happening inside courtrooms. Instead, courtrooms were these spaces just filled with people waiting and watching nothing happen, it seems. On the other hand, we're just watching incredible acts of state domination and violence happen through these routines that were going on. And so as a public defender, I had clients who was doing this work, but I was also sitting there sort of writing in the margins, either literally or in my head, about these spaces. I was, for a lot of the time, I was practicing in a building that was new at the time called the Bronx Hall of Justice. I don't know if anyone's been there. It's not so new anymore. It's falling apart. But it was built with, as a lot of newer courthouses are, with transparent walls, as if to, I'm sure there was some discussion they were really excited about this being kind of this open space of democracy, as an ideal court maybe could be. And so here we have these open spaces. Some of the rooms sort of looked kind of like this beautiful room we're in, except it said "In God We Trust," and had flags and things like that. And of course, there's a judge who's in a robe and you're sort of worshiping it in some way. So it's the space of violence and domination and real misery and boredom. At the time, you weren't even allowed to read in the audience. So a kid might be there with their homework and they would be yelled at and had to put it away and watch what was happening. And yet there was such potential, right? It was a room of people who lived in the community and were directly affected by the policing happening and by the judging happening and by the overworked public defenders who were running back and forth and by the prosecutors. And so there was this potential for something that you could feel. And if you spoke with clients and get them together, there could be collective action. And that was happening here and there. And so that's a long way of saying that then when I became a law professor, the first law review article I wrote was about how courts could be places of democracy if only we sort of noticed audiences and noticed things other than juries. And so now I think and write about collective resistance inside criminal courthouses and through criminal laws and criminal procedures, also state courthouses. But that includes things like court watching groups that come into those spaces and through their collective presence really can shift power in this site of domination. And so I've also sat now in criminal courtrooms where half the courtroom is wearing red t-shirts in support of someone being prosecuted by the Manhattan District Attorney in a way that just palpably changes what it means to sit inside of a courtroom. And that's through participatory defense efforts, which we can talk about more if we want. And so I think of courts, and I am also involved in write about the work of community bail funds, which would be groups of people that come and bail out strangers. And we might not think of that as something happening in a court, but it usually is. It's happening the bail is being set in a courtroom, and then bail is being posted using the rules of criminal procedure at a clerk's window, or sometimes a window at a jail. And just that act of communally paying bail for someone is incredibly powerful. And as these folks know, because my heart is still racing on top of it right now, across the nation, there are incredible attacks on bail funds happening. And there are pending bills in 4 different states to try to outlaw community bail funds. And that is not just because they free people from jail. It's because they're using the tools of the criminal court system to make a broad, collective, democratic statement about the unfairness of that system and the injustice of that system. And so I have other examples and we can get into it. But I think of courthouses and courtrooms, and I'm thinking local, state, municipal, and federal as sites of state domination, but also spaces in which collective resistance can be especially powerful because it's the site of domination.
Thank you. Thank you for having me here. It's an honor to be with the 3 of you and with all of you. I suppose in many ways, the path that got me to this organizing also started as a public defender. myself as a family defender in, thank you. So the path that got me here also started as a public defender myself, as a family defender in Brooklyn Family Court. I'm not sure that term means anything to folks in this room, so I'll explain what I mean by it, which is to say my role there was to represent parents whose families were policed by the child welfare system here in New York City, the Administration for Children's Services. Those of us who work in this area call the family police or the family regulation system. And I handled, hundreds and hundreds of cases there. And as I sort of stepped out of that work, out of the years in family court, I had opportunity to step back and think about, how cases got to family court. Especially in doing work that I was doing with the CLEAR project that Noah mentioned, doing Know Your Rights presentations, telling folks what to do if the FBI came and knocked on their door, and kind of affirmatively saying to folks, hey, look, if the feds come, you can say no, call CLEAR, we'll be your lawyers, we'll represent you. I got to thinking about what about when ACS knocks on the door of a mostly poor and mostly Black, mostly mother here in New York City? What capacity do they have to say no? So really, I kind of snuck onto this panel because I'm thinking about sort of what courts mean for what happens before things ever get to court. And I just pulled some numbers from notes that I had taken. Nationally, this is the last year before the pandemic. Something like 133,000 child welfare cases ended up in court. That's like the very, very tip of the iceberg, though, because when you scale back, there were 4 million plus reports into state registers around the country, and more than around 2.5 million investigations that were screened in, right? Every time there's a child protective investigation, a family is threatened with court involvement, right? A caseworker knocks on their door and says, hey, I'm here, from CPS, can I come in? Can I talk to your kids? They might ask them to rate their relationship with mommy and daddy 1 to 10. They might ask them to lift up their shirts and look at whether or not they have any marks and bruises. They might go through their fridges and their cabinets and go through their bedrooms. Of those 2.5 million cases, something like 600,000 are indicated, right? So we're talking about like a very small rate of indication, a very small rate of them saying, yes, we found some evidence that there was neglect. And even in those cases, neglect often means the same thing as poverty, right? We're talking about sort of conditions where people don't have adequate housing, don't have adequate food, don't have means to get their kids to school, are working multiple jobs and don't have childcare. So, then we come back to the 133,000 number and we say, okay, well, what about that 2 however many million folks who are left sort of holding the bag? Not to say, of course, that the court involvement is horrific and it involves often family separation and termination of parental rights. But what about the policing that happens with the threat of court as its main tool, with the threat of coercion as its main tool? And so myself and my colleague, Julia Hernandez at CUNY, the work that we do mostly focuses on representing folks in that space. Representing folks if ACS knocks on their door saying to them, hey, you do have a lawyer, actually. My most recent article is on sort of the Fourth Amendment rights of people when ACS comes to their door, and it turns out they have the same Fourth Amendment rights as anybody else who's investigated for cause by a state agent. And so maybe we can talk later about what it means to invoke that right and ask a court to get involved. But that's sort of the work that we're doing, is sort of in the shadow of that coercion, thinking about how we might push back even though that coercion is constantly on folks' minds because the same neighborhoods are policed, the same families are policed, and so on and so forth. So I guess I'll leave it there for now, and thanks again.
Well, if Tarek feels like he snuck on the panel, I really feel like I snuck on the panel. I'm here because I've been organizing around judicial selection for the last 2.5 years, which is no time at all. I stumbled into that because in late May 2021, then Governor Cuomo nominated a career prosecutor with a very carceral record at this is a moment of a sensible progressive change, especially Democrats around the country talking about needing greater racial justice and racial equity. And this was who the governor of New York turned to nominate for the New York Court of Appeals, New York's highest court. And I ended up on an email chain with Noah and some other lawyer friends of ours to say, who's going to stop this and how can we help them? And for a couple of days, we didn't hear anything. And so we said, well, we're going to do something. And that began now 2.5, almost 3 years of work like that for me. It's been mostly around the New York Court of Appeals, in part because there was a surprise vacancy 1.5 years ago for the judge position, which thankfully by then I was well positioned to organize very actively around and lead organizing efforts around. So what I know about courts and judges, I know not as a lawyer, which I technically am, but much more as an organizer, as a citizen, and I say citizen not in the legal definition of country citizenship, but just a person, a constituent of a government, which includes a judiciary, and someone who has who has held a belief that courts, like other parts of government on some level, are and should be accountable to the people that they ostensibly serve. And then efforts to, in fact, implement that, exercise, again, my rights as a citizen, as a person, to have some say over who sits on courts that will affect me, will affect all of you, and people I care about.
So thank you for these great opening thoughts. So just across these three, we've heard about 3 very different kinds of courts: the Court of Appeals, family courts, criminal courts. And we've heard about sort of these 2 sides of thinking about courts. So Jocelyn, you were talking about courts as sites of domination, but also possibly as sites of democracy. Tarek, you're describing the way in which the threat of courts can be used to really terrorize. But then at the end, you're suggesting actually there might be a kind of appeal to courts to protect your rights. And Pete, this is very sort of blunt, but you're talking about the dangers of having bad judges and the possibility, I guess, of having good judges. And so just a very sort of blunt question, which is, if you're interested in making progressive change, and we're thinking about the courts and judges, is our basic posture towards them one where we think of them as allies in the fight for a more just world, or as enemies and tools of domination that are basically standing in the way of a more just world?
Yes. It's both. It's always both. If we think of, when we talk about courts, we could think about the physical space, right? And I often think about that because I spent so many hours sitting in those physical spaces. We could think about the people in there, the state officials. It could be court officers. They're carrying guns. I have been pushed up against a wall by a court officer holding a gun. It is really scary. It's right there. They are enacting violence just by standing there with their guns. And we could think about lawyers. We can think about all the people in there, right? There's a stenographer, there's a clerk, and then the judge on the bench, often raised. So we can start to think about the people. We can start to think about the rules, which are written by the legislature. And through all of these things are flowing power and domination and violence. For non-lawyers out there who have ever looked at a law review article and been afraid of, I can recommend one of my 2 favorite law review articles ever. I can tell you, if anyone wants to know the other one, I'll tell you later, is an article called Violence in the Word. It's from the 80s in the Yale Law Journal by a Yale Law professor named Robert Cover. And it begins with a description of someone being sentenced to death in court, and talks about the violence of that act. sort of like writing out what of course is true when you stop and think about it, that executing somebody is of course an act of violence, but also declaring a death sentence in a room is equally violent, right? It's killing somebody through your words. And you can take that example and then let it ripple it out into all of the small acts of violence that happen. But for every time there's domination and power, there's power that flows in the other direction, anti-domination that flows in the other direction. And from my point of view, the way that that can and does happen is through collective action. And it could be people getting into that space, right? Sometimes it's occupying that space in a way that's civil disobedience. That's not a way you're supposed to be there. But the thing about courtrooms is the Constitution actually says we're allowed to be there, right? There's a First Amendment right to be in criminal courtrooms and to be in all courtrooms. And then there's a Sixth Amendment right to a speedy and public trial, which means that people are supposed to be allowed to be in courtrooms. So there are actually these, legal and constitutional concepts which solidify or just give some, ammunition to support courtrooms as spaces where collective interventions and collective ideas can come into these ideas of like what justice is or what we're trusting when we say that we're there. And so what does that mean if we're thinking about change? It means that, I'm a lawyer, I represented individuals. I think that's super important, but I don't think that's how collective change happens. Collective change happens through organizing and through people getting together, and courtrooms, criminal procedures, courthouses, the methods that we decide who gets to be a judge, a court officer, a public defender, whatever it might be, or who gets arrested and brought into courtrooms in the first place. All of those are places where people can collectively try to build power. And so not just change the outcome, but through the changing of the outcome, build power, take over that space that could be a site of democracy that the Constitution says is a site of democracy, right? Like there's something there. And I mean, I'd be happy to talk about examples. I mean, I've talked about court watching. Another one that does come to mind for me is participatory defense, which I'm most familiar with in the criminal context, and I can talk about, but it's not just about criminal courts. It happens in family courts, it happens in immigration courts, it happens in housing court. And it would be this idea that when somebody is as an individual being brought by the state or maybe by a private landlord into a courtroom to try to enact violence on them in some way, evict them, take their kids away, put them in jail, right? Often the caption is something like the people of the state of New York versus Jocelyn Simonson, right? Or name of landlord, company versus individual. It's just this one lone person standing there. And so participatory defense would be a group of people who have pending cases or have family members with pending cases and gather together regularly, often without lawyers in the room, to talk about what's happening in the case, and then to intervene in the cases, sometimes in small ways, sometimes by sitting in the courtroom. In criminal cases, often by doing things like putting together a photo album to explain the person's life, to show to a prosecutor or a defense attorney or a judge to try to humanize the person, just to try to place them as not an individual, but like a person who lives in society and lives in the world. And participatory defense hubs, the concept of collectively intervening in an individual case is as old as there's been individual cases. But this naming it as participatory defense is about 2 decades old. There are about 100 hubs around the country in criminal courts alone doing this work. And they absolutely are changing the outcomes of cases. In interviews I've done with participatory defense hub leaders and members, they often within the last month can tell me about a case where something has changed, but they've also will say cases where the literal legal outcome doesn't change, but still something powerful happens because somebody is individually supported, but also because collectively they're there bearing witness both inside and outside of the courthouse to what they're seeing. And that can lead to legislative change or maybe even just power building among this community and organizing that then that energy and that power gets transferred to other ways. You can think about theories of organizing and the flow of power and how it gets built even in the face of defeat. So I think courtrooms, even the ones that I'm imagining as places inherently of oppression, can be that way. What we haven't really mentioned is like this other possibility of like courtrooms as places of redistribution of money when something has gone wrong. I've never seen that happen, but I've heard it happens. And so I think there's also another world to think about, because I tend to study and be a part of groups that are in criminal courthouses with a belief that criminal courthouses shouldn't exist. Or those buildings should be emptied and turned in community centers and housing and things that do keep people safe. Because these are groups who believe, and I believe this too, that the violence of the criminal system isn't furthering public safety. So that's an interesting dynamic where you're inside a courthouse using the tools of the courtroom and don't think the courtroom should exist in the way it is. But I don't believe that we shouldn't have courts at all, right? That's a particular kind of a courtroom of criminal law, a particular kind of state violence. I think there's an interesting question about, say, housing court, right? I might not think that we should be, using marshals to evict people from their homes, but I do think we should have a system when someone doesn't have heat in their building to be able to bring in the state to try to fix it in some way, right? So courtrooms as a concept, I think there's also a world of just reimagining, like, what could a space of justice be? Maybe it does have glass walls. Like maybe that's actually an interesting idea about a democratic space in which there can be some kind of justice. So I just want to sort of name that I do think there's this other world of possibility that I'm not necessarily spending my energy in. Yeah.
Maybe I can pick up on some of the collective action threads that you laid down, Jocelyn, and concretize them a little bit in like an example that we think about a lot in our practicum at the law school, in the family defense practicum. In New York City alone, there are around 50,000 ACS investigations every year. ACS gets warrants to do searches of those homes in about 50 of those cases. That's 0.25%. ProPublica did a story about this about a year and a half ago. So, one thing we've spent a lot of time thinking about is, well, to the extent that we can build up lawyers that are sort of unexpected, right? Lawyers in places where they're not anticipated, as compared to lawyers in places where they are anticipated, and equip parents, caretakers, and others who are under threat of investigation by ACS. Say, hey, you can't come in, and if you want, go get a warrant and come back, right? If that happens once, twice, 5 times, 10 times, it's one thing, right? But it's something entirely different if the family court is being inundated with warrant applications by ACS. All of a sudden now that they have a very difficult decision to make, which is, do they continue to do all kinds of investigations that are just BS and end up not even indicating the report of this family? And again, I want to question whether an indication means anything here. And so that would mean hiring a whole bunch of new attorneys in a warrant unit. It would mean hiring judges to process warrants, which I'm not putting past the city or the state to do, and it's the sort of tension that we're dealing with here, right? Or do they make the decision that it's just not worth it to expend these resources on putting families through this kind of trauma because there is resistance in the form of collective action of folks who actually kind of are pushing back? So to the way maybe that you frame the question, Noah, I'm not actually sure that the court is doing the work of protecting folks' rights in that instance. I think it's just that the invocation of their rights is doing the work of putting a lot of pressure on the system itself, which is not actually designed at all to respect rights at all. In the CPS system, there's no suppression rule, meaning that even if someone comes in and gets evidence and they violate the Fourth Amendment to do it, you can't object in court. You can't say like, oh, that's, you know, not good. You got to throw it out. Fruit of the poisonous tree that you might have heard, right? That doesn't exist in family court. So for us, it's a front end problem. It's not about sort of like safeguarding rights down the line. It's about making it hell for the folks who are coming in and really terrorizing families across the city and across the country. And so that's one way that we think that the courts might actually act as a point of leverage for families who decide to invoke that point of leverage to the extent that they can. Because in other instances, when they don't, their refusal is treated as intransigence, right? Their refusal is noted down in the records as mom is uncooperative. Mom is mean. Mom has bad parental judgment. That's like the worst. But to the extent that those notes don't even make it into a court record because we've decided not past this point, right? That's the kind of point of leverage that we are imagining. So it's a slow process because 50,000 investigations is not nothing. And having lawyers ready to represent folks in that spot is also a kind of a different task than being in court, standing up next to a parent and figuring out how to get rid of the case after it's come in, right? But this is sort of the theory of how we imagine our role in this space.
You just, for people who don't know, clarify what ACS and CPS are.
Yes, thank you for asking, Corinne. So the Child Protective System, which is CPS in New York, is called the Administration for Children's Services, ACS, and I'll try and repeat that and other alphabet soup things. Thank you.
So I forget the exact binary you posed to the question, Noah, but I remember Jocelyn answered it yes. And so then I echo that to the extent, the question I think was like, are courts helpful or obstacles in working towards justice? Yes, I agree. They are both because they are powerful, because they are part of the government, and the government has power over our lives, and they're therefore, as long as they exist, in whatever form they exist, they're undeniable, necessary targets of our lawyering, our advocacy, our organizing. They might not be the best targets, they might not be the most efficient targets. I think there are some questions we'll be getting to later about like, should we bother? But to some extent, we have no choice, right? They are, as Tarek and Jocelyn have been saying, doing violence, potentially doing good, and so we have to. And I think it's a question of how, when, how much, and how do those possible engagements. And again, I'm speaking plurally, but thinking about like we organizers or we citizens, we people. How are we choosing to spend our time? Where are our energies best spent? And the answer isn't always on organizing around courts, but I'm pretty sure the answer is not never organizing around courts.
So just to piggyback off of that and maybe build on something that Tarek said when we were talking about what it is that courts respond to. So Tarek observed that one of the goals of a certain kind of advocacy can be to put pressure on the financial resources of courts. And the implicit premise is that, what courts really care about? How much money they have to spend on hiring staff attorneys and staffing up units and things like that. And Jocelyn, I think about in your example, the implication is that courts and the law really do care about who's in the courtroom and maybe even what's on their t-shirt. And so maybe just to zoom up and think a little bit more analytically, as we imagine a better world for courts, we got to grapple with the world we find ourselves in, where they are forces of some kind of oppression or terrorism or maintaining a pretty bad order. And can we think together for a second about what some of the factors are that courts are responding to in doing that? So what are the forces that we would have to organize against? What are the forces that are currently making courts be the sorts of institutions that they are? Does that make sense? What are the factors that the courts, as we currently have them, are actually responding to? not just the hopeful ones that
Sure,
we can
yeah.
organize around, but the ones that are keeping them in the position that they currently are in, where they're not always allies of progressive causes.
Yeah, I mean, I can start by naming a few, not exhaustive, and maybe we can gather some, and you should start doing some too. I mean, we've talked a little bit about money, but just to sort of, you know, to bring it in. And again, I am thinking about the space and the people and the rules, but also how it comes to be that a lot of municipal courts, which I don't even think we've talked about, it's not even state courts, it's like a county or a city, we have them here, are funded entirely from the fees and fines that they give out to the people who they bring through the municipal courts. And then those fees and fines in turn, you know, fees and fines in New York State help pay for public defenders. They help pay for district attorneys. So in some ways, we're bringing people into these courts and extracting the money from them. And this becomes a self-perpetuating system. And there are some towns, you know, Ferguson, Missouri is a famous example of this, just because the attention that, you know, came there in 2015 led to people and the Department of Justice and others and organizers in St. Louis unearthing what people who lived in Ferguson knew very well, which was that the extraction through traffic court, through misdemeanor court, through housing court of money from poor people was in turn really fueling a lot of the local economy of this county, in which so many people were employed as corrections officers and clerks. And so the more that if we, again, and I know I'm centering on the criminal system as I'm talking, I really don't mean to say that that equals courts, but if we use it as an example, to the extent we're using the criminal law and policing to try to solve our social problems, then that is where the capital is going to flow, and then it becomes a self-perpetuating system. And so again, that sounds like a negative force, but it does open up other possibilities of what we could be doing to try to solve those same problems. And if there's a way to flow political attention, including money, toward those other things, it does take away power from the courts. I was going to name some others, but maybe I'll allow you all to name some.
Yeah, I can maybe name one. I think attention is something that courts respond to. You know, at least in the context of family court, like the thing that they're most afraid of is bad press for something that they miss. A case that goes terribly wrong. The sort of needle in the haystack example, the exception that proves the rule, is something that frames, at least in that context, at least in the family court context when it comes to child protective services, the rule is built around the exception. Everything is treated as if it can be the worst possible case. And so we end up really with a security theater in the context of family policing, where you know, the whole edifice is designed to convince the broader polity that CPS, Child Protective Services, is doing the work of protecting children, and spending all of these billions of dollars on doing that, when in fact, attention in the opposite direction. You know, New York Times top of the fold stories where ACS is held out by their own, the Administration for Children's Services is held out by their own workers as a racist institution, you know, kind of flips the script and puts a different type of pressure on courts. And I mean, we have another example from my time working in CLEAR of a participatory defense case in an immigration context where we had a really terrible judge, and she was racist against our client and was saying really terrible things about our client. And we were at our wit's end. We kind of just didn't know what to do. The legal arguments weren't working. She was sanctioning us left and right for the arguments that we were making in court with our students, sanctioning the students, you know, footnoting how terrible we are as advisors, you know, that kind of thing to our students. And so we sort of got together the communities of concern for this individual who was being held at Elizabeth Detention Center, and built a campaign around this individual's release that involved a petition around the conditions that ended up resulting in his detention, which included the Muslim ban at the time, and his sort of the various illnesses that he contracted in detention. But also, importantly, like press stories, both about the judge and about his case. And when these stories started to come out, lo and behold, the judge wasn't treating us the same way. The judge was reacting quite differently when a student got up in front of her. Oh yeah, oh, thank you. I'm so glad that there's students in the classroom. Sorry, students in the courtroom. Also a classroom. And so that sort of press, and ultimately he was released. And I think without that sort of pressure and attention, he could very well have been forgotten. He could have very well been deported. So that sort of pressure, I think, attention, both the sort of like reactionary kind and the sort of power building kind on our end, really, I think, can yield results.
I'm glad the prompt wasn't to be comprehensive about all the things that courts are responsive to, because I can't be, I don't know that in this hour we can be, but I wish I had read more LPE materials so far and thought more about political economy, because my first thought is probably the answer is in political economy, that courts are, speaking to some of the stuff Jocelyn said, responsive to very material realities of power and wealth, and not always perpetuating those, but I see inertia in Tarek's notes, so sorry to take that from you, but largely, acting on the force of inertia, keeping things going as they are, and need to be shaken out of that. To add one more thing that's related but distinct, I think also courts, like probably most institutions, are very responsive to whatever is like the dominant ideology or the dominant norms of the people in and around them, mostly people with power, so judges and lawyers, but of course more than that. And so the legal profession, the judiciary, these various big sort of subsets of our society have lots of ideas about how things should be done. And I imagine that courts are highly responsive to the dominant ideas within those groups of people. And those ideas can change. They do change over time. It's therefore incumbent on us to seek to change them.
So just a small quick follow-up on this topic. I'm sort of struck that none of the three of you point to partisan politics, which obviously is so much in the news, especially when we talk about things like the Supreme Court. Can I just ask you just maybe briefly to think about that with us for a second? Is that because actually in your experience of the courts, that's not the right focus?
Peter, do you want to jump into that?
Sure. I mean, I think so little about partisan politics in this context because my experience of organizing on courts is entirely in New York, where the Democratic Party is dominant. So, not in every part of the state, but in New York City, it's generally dominant. It is sort of like, I don't know if it's at the top or the bottom of the structure, but there aren't partisan fights. The sort of closest that exists, the partisan fights at the national level map onto fights that are political fights that are generally happening within the Democratic Party here in New York City and New York State. And I find them very interesting, but I don't think of them as partisan fights.
Yeah, I mean, this week, a lot of my sort of outside the classroom energy has been spent thinking about pending legislation in 4 states, Georgia, Kentucky, Virginia, and Tennessee. So not the reddest states in the world, right? Some of them, didn't vote for Trump, but purple to red legislatures. I think Virginia's legislature might technically be Democratic.
Yeah.
And all 4 of these states have pending legislation, some closer than others. In Georgia, it's about to be signed, that are either outlawing entirely or severely limiting the ability of people to post bail for someone who they're not related to. And so this is a question of courts, and it's a question of freeing people from the violence of jail on the one hand, but also it's literally about people coming in and intervening in a court in a way that we have always allowed people to do, which is gather money together, pass a hat, pay bail for your neighbor. And the reason these bills exist are not because legislators are genuinely worried about public safety, but because of a combination of rhetoric that is bipartisan rhetoric about public safety and a rise in crime that is sort of not backed by the world. But also the reason it is happening right now with bail funds is because bail funds have been gaining power through people coming together and when posting bail, not just freeing somebody who's a stranger, but making a larger ideological statement that threatens the system, right? You're saying that you're putting someone in jail for public safety, but we actually are the public and we feel safer if that person is free. And so I've been having conversations both about like how to talk to legislators or just how to organize and contest what's happening. And on the one hand, you could think of this as a partisan Republican state. On the other hand, these conversations are exactly the conversations we're having in New York. Like it's just the same conversation. And maybe this is a question of the carceral state and the hold that policing and this rhetoric of public safety has, especially now, and especially in this moment of rising repression, verging on fascism or ugly fascism of social movements that are contesting the carceral state. So it could be a unique thing. But because we revere the federal constitution and talk about the Supreme Court so much, these lower courts actually don't become big partisan issues. They become a taken for granted moment, place of inertia, place of oppression, which seem like easy wins for politicians rather than the other way around. It doesn't have to be that way. You two might sort of not brag as much as you should be doing, but like when it came to who's going to be on the Court of Appeals, you were part of what I would think of as a relatively partisan fight. I could be wrong, or just a political fight, right? A political fight about a spectrum between right and left to say this person, I guess he was a Democrat, is not fit to be on the Court of Appeals because of the things and decisions that he's done, some of which were about being very carceral, right? You won that fight. We won that fight, however you want to think about it, right? And that was a political fight that involved organizing what was fought along just kind of like fairly traditional political means, right? Like conversations with legislators in the governor's office, op-eds. I mean, I could be wrong, going to Albany, right? All of us have probably at some point gotten on a bus to Albany for a day and talked to legislators, and like that's happening. There's politics involved in courts. Just this week, there was a day where public defenders went up to beg legislators for money, right? All day. That was what they did all day. I don't think it worked, but they gave it a go. And so it's political, but it just doesn't fall along these neat red and blue lines that you might think, characterize a lot of politics. Yeah.
She said.
Well, so I want to hold on to the question of the relationship between courts and politics. We can come back to it later because it's such a big one. But I think this conversation really did highlight that the kinds of political economy concerns that we're worried about might not track the straight Democrat-Republican divisions that we tend to read about most frequently in the papers. I do want to come back to, Jocelyn, you keep pointing out it could be different, it really could be different. And one of the ways you're encouraging us to do that is to say, the criminal court, maybe that's necessarily going to be the site of oppression precisely because it's not actually committed to public safety, but we can imagine other kinds of courts that could be. And so maybe we could just take a couple minutes and try to imagine what would courts be able to do to advance social justice. Suppose that we were going to try to paint the sunniest vision. What would or what could the courts do, or what might they look like?
Yeah, I can offer sort of a recent example that I watched and sort of tangentially participated in that I was inspired by, and I'm gonna draw on an example from a federal court, so y'all will hopefully excuse me. The Center for Constitutional Rights recently brought a lawsuit against the Biden administration for aiding and abetting the genocide in Gaza. They brought this in the Northern District of California on the grounds that Joe Biden and his administration have obligations under the Geneva Convention, which forbid them from aiding and abetting a genocide and require them to prevent genocide. So they demanded a hearing in the case. In particular, they sought what's called a preliminary injunction, basically saying, Judge, we're asking you to order the administration now to stop the Biden administration from sending funds over to Israel during this onslaught, which has resulted in the death now of nearly 30,000 people. Days before the hearing was held, the International Court of Justice, which is a UN, the highest court in the UN, found in fact that yes, there's a plausible case of genocide in this context. So CCR did this really brilliant thing where they asked the judge, they said, you know, we know we're arguing a legal case, and the issue was kind of a narrow question about whether or not a court has the political authority to tell the president what to do when it comes to how he spends his money on foreign relations. Isn't that just what the president is supposed to do, or can a court weigh in on that when there's genocide, right? So that was a legal question that they were asking and answering. And they had some people arguing that, and those people were graduates of CUNY Law School, I'll say. But beyond that, what they did, which was so innovative in my mind, and just so powerful in terms of how they used the court to tell a story, is they asked the judge if they could have the plaintiffs who were suing, who were Americans, Palestinian Americans from Gaza, and in fact, a doctor who testified from a hospital in Gaza, if those people could testify in court. And this doesn't really happen at this stage of litigation. It's not something that normally happens, but the judge allowed it. They asked for the moon multiple times. And each one of these people came up and testified to a Zoom that was 1,000 people full and was packed. People couldn't get in. It was capped off at 1,000. And a full courtroom. I implore you to go and watch the testimony because it's quite powerful. But most importantly, I want you to watch the judge's face. Because even if the question that he's deciding on is a question of the political question doctrine, which is, so asinine and yeah, I guess I have no reason. Yes, it's so asinine and sort of doesn't actually make sense in this context where we're talking about whether or not a genocide is happening, yes or no. The judge, you could see it on his face, y'all. You could see it on his face. He's, I have to do something. Even if I can't rule for these folks, I have to do something. Your Honor, this might take a little longer than the 2 hours we were planning. Is that okay? Yes, go as long as you need to go. I need to hear this. The world needs to hear this. At the end of the testimony, the judge said, who also was a CUNY graduate, by the way, undergrad, but still. Public universities. He said this has been the most difficult case that I've heard in my 27 years on the bench. And ultimately, because courts are courts, as we know them to be, he dismissed the case on the political question doctrine. But in his ruling, he said, the uncontroverted evidence that I have heard suggests that there's a genocide happening in Gaza. He put that in a federal court. And he said, while it's not technically within my authority as a judge, I implore the Biden administration to do something about this. But I can't remember the exact wording. He said something like, there comes cases where you can't do the thing that you want to do. case dismissed. And after the hearing ended, the plaintiffs walked out into a demonstration that had been happening all morning, where they held their own press conference addressing hundreds of thousands of folks watching online, maybe not hundreds of thousands, thousands and thousands of folks watching online, demonstrating sort of the power of what they had just done, right? And so ultimately, that's a win. That is sort of the kind of thing I think, Noah, that you're asking about in terms of what a court could do, even if they feel they're restricted by the law, right? There are steps that they can take to make space, like Jocelyn was talking about, to open the space as much as they can, to shrink the space to the right of the accept, and make it such that as many people fit in the sentence before the comma can. So to my mind, that is a really concrete example of how sort of movements can work together to put popular pressure on a court to do something that even if they don't find the right ruling legally. I mean, I've told my friends at CCR that these guys are like professional losers. Like that even if they don't do the right thing, that the court's ruling means something. So to me, the whole thing is quite emotional. And I really suggest that y'all watch it if you have a chance. It was up on the court's website within an hour of the testimony. That's how important the judge, I think, thought it was.
I would add, the courts can, at times, courts can expand our rights. Courts can change, the balance of power. They don't do so nearly as often as many of us, not all of us here would like, but famous examples that we're familiar with come from, the Warren Court years where, the Supreme Court did lots of things that are celebrated today. But there are examples that none of us will ever know about because it was one judge in one courtroom in a way, if not expanding all of our rights, giving greater rights to an individual litigant, an individual person. Outside of New York, some of my organizing has involved connecting with people who have organized around judicial selection to state courts in other states, sometimes as candidates themselves, people who have run for judge or sought to be appointed to judgeships. And one person comes to mind who was a lawyer in Houston who in 2018 ran for judge in Harris County, I forget which court it was, endorsed, as far as I know, only by the Houston chapter of the Democratic Socialists of America, running as a socialist judge. Now, I identify as a socialist. I can tell you what a socialist judge is or would do because I haven't thought much about it. But here was a guy in Houston, Texas, who said, I'm going to run for judge on a socialist platform. And he won in 2018. And for 4 years, I'm sure lots of ways I don't know about, that was the length of his term, did his best to be a radical judge, very different from the judges who inspired him to run before that. 4 years later, he ran for re-election and did not win because political currents change and radicals make enemies and all of that. But I offer this, as a story of individual judges can be allies, can expand rights, can do justice, and sometimes, perhaps rarely, courts as powerful as the Supreme Court can do the same.
I love these examples. I get the one thing I'd add is that another way to think about it is kind of like, what is a court? And could we think of collective democratic spaces of justice that don't look like what we think a court looks like? Like there's not somebody in a robe on a dais. There's not a flag and in God we trust. There aren't guns and you don't have to be quiet. If we're thinking about like how to deal with harm, a lot of the people who are organizing through participatory defense and bail funds don't think criminal courts should exist, but they don't think we should do nothing when someone gets harmed. They imagine collective responses through restorative or transformative justice. And right now we don't call that a court, but it could take the place of what we imagine courts to be doing. I don't think that means we don't have courts though. Courts can become something else. Like if criminal courts don't exist, then we might have collective spaces. Maybe the state is helping fund that but there's not a judge presiding over it, and there aren't court officers with guns, and it's probably not in that glass hall of justice building, right? It's somewhere else, but maybe that building can be a site of democracy in some way. You know, one thing that really stuck with me was a time that I was in a crowded criminal courtroom. It was a felony arraignment courtroom, just a place of pure misery. And absolutely packed with well over 100 people waiting for their loved ones to come in front of a judge and be arraigned on a felony indictment. And as I said before, the audience was entirely people of color. And at this moment, the judge was a Black man. And a young Black boy walked into the audience with an older woman, perhaps his mom, or sorry, not an older one, not an older man. And there are kids in court all the time because if parents can't take them to school, they have to bring them to court. And this boy looked around this crowded courtroom and saw a person up on a dais and saw a room full of Black and brown people and said really loudly, because he's a kid, "Daddy, are we in church?" But instead of church with like joy and worship of, you know, collectively taking care of each other or whatever you think of church as, the boy then sat down and watched either his father or a loved one come out in handcuffs in front of a judge who is in the state enacting violence on a person, right? It's just the opposite. And so again, there's this tension of like, there's this moment of possibility. There is this community sitting in these spaces, and we are doing the opposite of healing collective justice and enabling democracy. And so I don't have the answer to what ideal courts could look like, but I have faith that there's another way that we can arrange public spaces to achieve some kind of justice.
So I'm hearing across the three of these comments, different things that are preventing courts from playing this more collectively just democratic role. Jocelyn, you're talking about the architecture of the courtroom and the actual scene of the courtroom. Tarek, you referenced in part legal doctrine. Yes, it was a win for CCR, but at the end of the day, the judge sat there and said, look, the law constrains me in this way. Pete, you were referring to the personnel, the good judges who can expand it or be more creative. And so just before we turn to sort of thinking of collective organizing to make courts better, and after that, I'll open it to questions, just to stick for a little longer with what some of the reasons why our courts are not as great as they could be. So what might some of the other things be that are preventing courts of these different forms from playing this more transformative or emancipatory or positive role besides just, I mean, and I don't mean just dismissively, but the three that we've just heard. So the scene of the courtroom, the doctrine of the law, the personnel of the judges.
I was just going to name a quick one,
Go ahead.
which is that we don't, you know, juries are supposed to be this moment of democratic engagement, and we don't really have them. So well over 95% of criminal cases that end in a disposition of any kind have a trial. A smaller percentage of that ends up with a jury, and that doesn't even include the amount of cases which are dismissed, which can be up to a third of cases. So we rarely have juries in criminal cases. We very, very, very rarely have juries in civil cases. And juries actually, I love trials. I did trials. I love juries. I actually think there are a moment of public engagement with what ideas of justice are. And so even in a system that I don't think should exist like criminal law, I still think trials can be beautiful, positive things, but we don't have them. So plea bargaining, settlements, and other disincentives to get to trial.
I believe something that I know not everyone believes, but I said it before and I'll reiterate it, that courts are part of government and government exists to serve people. If courts are not serving people, serving the people, I think they are failing, you know, their reason for existence. And serving the people doesn't mean doing exactly what the people want. You know, we have three branches of government, generally speaking, and they do have different functions. And there is some, I think there are good arguments for courts to be less democratically responsive, less majoritarian, whatever way you want to think of it, than the other branches. But if they are not those things at all, I think they are likely to fail us. And so, like, how could they be better? They could be more of those things. Again, not identically to how we want our executives to be, our legislatures to be, but right now, generally speaking, and again, I'm most familiar with New York's courts, but the federal courts in ways that we're probably all somewhat familiar with, and then probably all 50 state court systems in different ways are structurally set up to be very, very resistant to any kind of democratic input, popular input, change over time from the political processes, et cetera. And I think that does a disservice to courts and a disservice to us.
Yeah, I mean, just to really quickly add something that we talked about before. I mean, I think here's another place where inertia plays a pretty big role. In legal parlance, it's called precedent. No, I'm just kidding. Inertia, I think, plays a really big role in sort of kind of hardening the way that courts operate. I mean, this notion of sort of democratic accountability in which those folks who are most policed and harmed by courts might have a say in how courts function. It's just unfathomable would be unfathomable to most of the judges I appeared before in family court. The same is true of like sort of, the idea of raising a constitutional objection in a family court. I've literally been laughed out of a courtroom upon sort of such an objection. So the inertia of sort of the way things are done is a really, really powerful force that I think with the sorts of things we are about to talk about could be interrupted.
So let's go there, and then I'll turn it over to the audience for questions. But so, all right, how are we going to interrupt it? So if we're thinking about overcoming the inertia and some of the other factors that we've identified that keep courts from living up to this promise, or at the very least, from opening the horizons that would allow us to imagine something else. I wonder if we could spend a little bit of time talking about what kind of organizing or collective action is going to help us get there. So we've already had several examples: community bail funds, participatory defense, direct political pressure on judges, attention. But for those who are online and for those who are here in the room thinking about their own organizing projects, if they come to recognize some of the ways that courts are not living up to their potential, what would you recommend they start to do to overcome this inertia and start to push courts in a better direction?
In addition to bail funds and participatory defense, court watching groups have, I think, experienced a lot of collective power through the act of observation of what happens in court. And so, everybody, if you haven't, go to court and watch what's happening. Any court, go to housing court. You'll see the action happening in the hallway, but you can watch that. Go to criminal court. Even better, go as a group and sit there visibly. Maybe you're wearing matching t-shirts, who knows, to show that you care about what's happening in your community. And then after that, go out for a cup of tea and talk about what you saw, and then tell people about it, and then get more people to come to your meeting, and then go back to court. Like, use courts as a site of organizing, even at the same time that they're a site of domination. I mentioned juries. One of the powers that juries have in criminal cases is actually to nullify cases, to find people not guilty even when they're guilty. So another kind of organizing is to raise consciousness around jury nullification, or to find ways to open up juries in other ways. And I guess one other thing I would name, and then I would love to hear more examples, is that sometimes organizing around courts doesn't happen in courts, even though you can tell I think about courtroom spaces a lot. When it comes to fighting pretrial detention and bail, for example, some of the most powerful moments have been when people have gathered and done their own people's hearing on pretrial detention. So in Philadelphia, 2 community bail funds and other organizers got together in an open community space, and they held their own people's hearing. And they asked the district attorney and local politicians to come, and they came. And they're the ones who asked them questions, and they gave testimony. And so it was sort of like a courtroom, like a hearing. It's kind of like this beautiful hearing, but instead they had to create it, right? Or people create moments of restorative justice where people decide not to call the police and then try to work things out. So there are ways to live out and sort of prefigure what courts can be, which actually are a form of resistance and can't have it.
I want to piggyback quickly on the court watching point and say that it's a good site from which to expand your understanding of which courts should be watched. At least in New York, family court is open to the public. There isn't a court watching project that's like robust in New York. Just going to family court, for example, in addition to any other type of court, housing court or immigration court, whatever the case may be, and doing the sorts of things Jocelyn mentioned is powerful. It both keeps the judge accountable, who's sort of sitting there and knows you're there, and the others in the courtroom, but offers another place, sort of site for organizing. So I want to plug that and really make a plug for sort of diversifying your sort of like understanding of which courts deserve your attention, where violence happens, because certainly it happens in criminal courts in the ways that we all know and some of us experience either directly or tangentially, but it happens in other courtrooms as well. So I think it's worth thinking about that. There are other there are legislative tweaks that have the potential to impact courts. So for example, in family court in New York, there's a move towards what organizers are calling family Miranda. So this notion that ACS actually has to tell a family that they have a right to not let them in at the front door, which would theoretically have an impact on the kind of thing that we were talking about at the beginning of the conversation. And that organizing effort, which is led by JMAC for Families and some of the defenders' offices here in New York City, is itself a site of organizing around courts, and it offers other opportunities to hear about affected folks and their experiences in court, and also to the extent that another case comes up, there's now a site of organizing and potentially participatory defense there too. So those are sort of 1.5 additional ideas.
The question of what can we do around courts, what can we do to make them better in whatever way, how do we define better? This occupied me for the last 2.5 years, and I have far more questions than I have answers. But it's been really exciting to think through and begin to experiment with some things that, for me at least, have been new in the last few years. Generally, I think about it in 2 categories, and this is definitely kind of like limiting the expansiveness. I'm sure there are other ways of thinking about this, but there are opportunities to make the people currently on the bench better than they are, make courts better than they currently are, and there are opportunities to change who's sitting on the bench. And so, a lot that Jocelyn and Tarek have spoken to, in my mind, fit in the first category. I often think of it as judicial accountability, though the term doesn't really matter. It is taking whoever is in the courtroom at any given time and trying to hold them accountable. And there are all sorts of tactics, some tried, some untried, some more successful so far than others, but very much, I think, worth doing, worth all of us participating in and continuing to experiment with. And then there's literally changing who the judges are. This is what I've spent more of my time on recently. It, I think, is helpful, valuable. We've shown that new strategies and tactics for this can succeed. And it's also slow going. I mean, there are tens of thousands of judges across the country, probably, if not hundreds of thousands. I don't know, certainly tens of thousands. They don't all need to be replaced, but a lot of them should be replaced. And it's hard work. So I think both of those offer a lot of promise. The more people fitting in, I mean, Jocelyn was talking about court, like everyone should court watch. I completely agree. And also I would love for everyone to engage somehow with judicial selection, because we can, and we should, more than we collectively have historically.
And if I can just add, I agree that judges are important. And I think the other thing we should remember is other people in the courtroom, including the fact that in the US, for the most part, you don't have a case in court unless someone brings that case. So in criminal court, there are prosecutors who there's no case they have to prosecute. Every single case, they are making a decision. We are going to use the violence of this courtroom and jail and capital punishment to solve this particular problem that we think happened. Every time there's an abuse and neglect case in family court, a state actor, right, that New York City, right, in our names has decided that they are going to bring this suit. Every time an eviction hearing is brought, it's either a government agency like the New York City Housing Authority doing it in our name, or a landlord of some kind, sometimes a big company, sometimes an individual deciding to bring that case. In immigration court, there's a federal immigration prosecutor deciding to bring that case. And every moment, these are actors. Some of them are elected, like most district attorneys are elected. Federal prosecutors are not elected, though. Some are private parties, but even, you know, private parties can be influenced in different ways. And so it's, I think, also just sort of knowing where the power flows. And then, you know, lawyers actually haven't come up that much, I guess, although we are them. And I was a public defender. I mean, I think it's also thinking about the role of lawyers, how we lawyer, not assuming that just giving somebody on the other side a lawyer makes things equal and good, but asking how lawyers can be a part of this power building and this larger change rather than just representing individuals. Yeah.
Well, great. So lots of ideas to think about, and we still have plenty of time for questions and conversation. So with that, let me turn it over to the audience. If you have a question here in the room, please raise your hand and I will scurry over to you with a microphone. And if you're online and you have a question, please just put it in the chat and I'll take a look at it and try to bring it to the attention of our panelists. Do we have any questions in the room? And if you could just introduce yourself.
Hi, my name is Dash. I work in policy at a supportive housing order. And my question, I'm interested in sort of steps that we can take right now. And I appreciate a number of them that you shared. And I'm interested in an additional one, which is sort of, you know, through politics changing which crimes, which transgressions are more of a focus. And an example I'll give is source of income discrimination, which is something that we deal with all the time at times, which is illegal in New York State now.
Do you mind saying what that is?
Yeah, essentially the landlords refuse to accept shelter holders as tenants, like categorically, you know. And so it is illegal, but it also happens all the time. Like they just did it again, turning people away explicitly because of shelters. And enforcement is, you know, extremely lax, and that's partially due to understaffed units, and you know, partially due to difficulty proving it. But it's something like that that could be a larger focus in courtrooms if, you know, measures were taken politically. In fact, they have been proposed by the governor, and you know, we hope to see this, you know, maybe make this session. But I'm curious about other things like that are like, okay, if we're to focus more on XYZ crimes, which currently are basically like being done by more powerful people, or just
Yeah, I think there's two ways to ask that question. One would be, should courts be focusing on different crimes than they are? And another would be, should courts and the political system be focusing on different kinds of like harm and wrongdoing? And I prefer the second way to think about it, because in my experience, every time that we encourage a court to engage in a prosecution, we're kind of enhancing the power of the criminal courts to do what they do normally against poor people rather than people in power who are oppressing. But what I love about this question, it's sort of like, what if we redistributed our money, power, attention in these public democratic spaces to call out wrongdoing and try to remedy it and prevent it? I'm not convinced that courts can do that entirely, but courts can be a place and a site of, raising these issues, testifying about it, and ordering people to do certain things. I'm not familiar with the bill and whether it creates a new crime or is more like a cause of action so that there are mechanisms of enforcement like fines and contempt and things that might feel like criminal punishment, but aren't sort of saying you have a criminal record and you're a bad person and we use the criminal law to solve problems, but rather like housing court can be a space of justice in which we don't let discrimination against poor people happen in certain ways. But I want to hear more about that though later.
Other questions?
Thank you guys so much for your time. I guess my question is like, so I guess I'm a law student and I've been thinking a lot about like the silly opinions that we read every day. And I guess to me, like a lot of the things that I see like in my own experience reading about courtrooms and like being in courtrooms is like, I think I started to attribute a lot more to like organizational psychology. And I guess my question for you folks is, like when you were talking about like the courtroom as like potentially like a space for social justice, for like redistributing power in the community, to me, like a lot of this seems to be about like creating almost like social solidarities, like both among like people within the community and like judges who are also members of the community, but often occupy a very different space. And so I think, like, Bobby, to your point earlier about like, the Northern District of California case where like a bunch of people showed up and, the judge like acknowledged that this is kind of like outside of his control to like act upon. I guess like I'm curious, like that seems like one way to like show social solidarity like within the courtroom. But I guess my question for you folks is like, are there other ways that you see, insofar as judges remain very like, important players in our like justice system, to like kind of apply pressure to them, both within the courtroom but also like without and like adjacent to the courtroom?
I'll provide one answer. This is untested and aspirational, or maybe being tested as we speak. I don't have the test results back. So we've spoken a little bit about the campaign that I ran around this judicial vacancy, the chief judge vacancy. So when we started the campaign, we were advancing an affirmative vision. We articulated about what we wanted to see from the next chief judge. The Governor Hochul's first nominee was not that. We had to fight that nomination, which we didn't want to do, and we were not trying to make a sort of big picture, long-term thing about fighting him. We were trying to keep a specific person out of the seat. But one thing that became very clear to me while that nomination was live, while we were fighting it, and then much more so after it was defeated, was what a threat it represented to a lot of people. I want to say what it represented to judges. I didn't hear directly from any judges, but people, we were sensing sort of secondhand the threat, our advocacy in this moment of judicial selection, what it represented to people on the bench right now, because it was saying things that you're doing today could have impact on you later. You get nominated for some other judgeship, or whatever your personal ambitions are, it's in this sphere, you might be held accountable for what you're doing today. And on some level, in the specifics of that fight, I hope it had those effects. And I think that speaks somewhat to your question. We can try to, apply pressure and influence people over time by making clear in the opportunities we have, at least judicial selection. We care, hear ways we care, and we are paying attention to things you've done in the past, and also we're paying attention to things other people are doing right now. You'll see that in the future.
Thanks for this, Vincent, lawyer. So I guess one thing I'm trying to struggle with in mind is, all we talk about, of course, describe course in a way that I understand it's like protecting status quo. And Kurt mentioned this idea of, for example, if we required folks to get warrants every time happens in the store, would courts like just open and say it's not worth it? And I guess what I'm grappling with is like I think they would not say it's not worth it, just expand resources necessary to continue to do the harm. So first, what I'm struggling with is how do you disrupt that normative value that courts inherently give, which is to perpetually harm, perpetually status quo, perpetually harm. So, concerning. So I don't know.
Yeah.
It's a hard opportunity to ask the question. It's just an observation that I'm trying to like grapple with.
Yeah, I mean, this is the response that criminal defenders often give me on this question of like, well, what are courts going to do if that pressure is put on them? If there are warrant application after warrant application after warrant application, what's going to happen, right? And I think the question isn't so much about what the court does, because the court might just become a rubber stamp, right? Just like they are in the criminal context, right? A warrant, what's the standard, right? But I think the question then becomes like, you open up a space for political organizing. Once that's happening, like it might not, the court might rubber stamp, but ACS in this context, the family court legal services that represent them, are going to have to hire more lawyers to do that work, and that's a space for debate, right? That's a space for political conversation about like, do we really want to allocate all this money so that y'all can keep doing the thing that y'all are doing? Do you really want to allocate all this money to CPS, do all these additional investigations that are now being rubber stamped? And it also opens up a conversation at that moment for what standards is actually being used in court when you're signing off on an agent going to someone's house. That's not restricted in the way criminal warrant is to like a drawer, let's say. Of course, I know that that's not the case, but that it opens up that space for a political conversation. So I think, in answer to your question, Vincent, it's not like I don't think it's a magic wand, but I do think it's a point of leverage to open up a political conversation about how we want to spend our money as a society. And if our answer is like, well, we want more lawyers so that they can submit more applications before a judge so that they can sign off on them, let's have that debate. Like I'm up for having that debate, but I think that's one way to force the debate. Debate is not happening at this juncture of the very least.
Yeah, I'm sorry, I forget if there are a lot more hands, but just really quickly, I love about this observation, which was a question, is that it's sort of noticing that, something like Miranda, again, my public defender mind is like, Miranda's not going to do anything, but maybe it could, right? I think that having public defenders can legitimize what's happening in a system. I think the right to counsel in housing court can legitimize evictions. I think Miranda can legitimize taking kids away from their families, but it doesn't mean it has to. And I think this is maybe what you're getting at, is that any right or procedure can absolutely legitimize what's happening if we let it. And sometimes we can't help but let it. But if there isn't organizing and political pressure moving against it. So I just don't think there's any right or procedure that will help on its own. But if it's a moment or an opening of political possibility, then maybe it can.
I'll just add briefly, I am not an economist. I feel like tonight I'm like thinking in economics lingo, which is very weird for me. And so maybe this is more aspirational than realistic, but well, I'm doing my best. I think about like efficiencies and frictions, and to the extent we want to limit things, we should create more frictions, we should try to slow them down, and it doesn't always work, and sometimes it's other expansions, but short of ending things, let's try to make them more expensive, more difficult, more frictionful.
And so, illuminating discussion a lot, I think. So I'm thinking that community development and institution are surrounded by this. But long time LPE anyway. And so I was wondering, the discussion did go in a place that I thought it might, which is avenues for kind of more direct popular democracy position of the court system. And I think that one of the things that really striking to me, thinking about state and local courts, is that they're judges. They are not all, appointed in the way they are in the courts. And part of this is personal. And I live in a district in the city where there are swing districts and swing votes. There's been also acknowledging that in a lot of the squarely democratic districts in the city, these are elections that people aren't paying attention to, or folks are chosen by the Democratic clause. But it seems like there is an opportunity for more expansive popular democratic engagement around who are putting in the judiciary and who ascends the higher levels of local and state court systems. So I guess, but then it's also really frustrating when you go and try to learn about what you're voting for, and it's like maybe a web page sometimes, occasionally they have a Twitter, and it's just hard. I think if you're not actually. So I'm curious about what you think the possibility. One, is it a productive avenue of engagement? Is it relevant given the other kind of injustices within the current system as it's structured? Two, are there more reforms that we can implement at the state constitutional level that would broaden the scope of what levels of the judiciary at the local and state levels are elected? Or is it just is that the answer?
I think it's a great question, and I think the fact that we elect judges, in the criminal context, is sometimes assumed to be a terrible thing, because in the U.S., this like pro-carceral mindset is usually a winning political move, but in the criminal legal space, we've actually in the last decade or so seen moments where people are putting a lot of organizing and a lot of money into discrete fights over elected judgeships and also elected prosecutors, both elected officials that traditionally are not contested positions, so they're just assumed to be in for putting everybody in jail and prison who they can legally or whatever the way they think about it is. And those fights are happening, and sometimes they're happening successfully. And again, to go to this partisan thing, like sometimes it's in democratic cities, sometimes it's in red states. It really varies. I was recently in Los Angeles where, because my book talks about court watchers, I'm trying to engage with court watchers where I go. And so Court Watch LA was in a public discussion with me. And one of the things that they're doing, in addition to watching criminal court, they're noting which judges do what, which is sort of what your method is. And then they're trying to find decarceral judges to run against those judges. So they're combining the power of court watching with finding often public defenders who are going to, and it's actually happening in this election now. I'm not saying they're winning all the seats, but like they're going for it and they're targeting that. And that's in Los Angeles, which you might think is a democratic place, but actually, like here, right, is a site of mass incarceration and police violence, sort of essentially in what it does. So yes, but oh my goodness, it takes a lot of money and a lot of people to have those fights. So that's where we could be putting energy. Yeah.
Sorry to sound like a guidance counselor therapist, but apathy is not the answer. If only because it won't do anything. But more people with those local elections. Well, but actually, what I was going to say is the apathy is really warranted because more people voting in local elections by itself won't solve the problem. Like that, I mean, you identified all of the reasons why simply voting for judges is not necessarily going to yield different results. people don't know, elections are uncontested, the candidates are selected by parties. I mean, it goes on and on. And so on one hand, I want to say, no, don't be apathetic, but truly, please don't be apathetic, but also you're right to identify a whole range of things that are beyond the power of any one person or any small group of citizens to influence. So, I mean, my long answer will be much too long, but I'm happy to talk more later. There are, if you're asking in the New York context, there are, I think, potentially promising interventions for groups of citizens, for people engaging with political parties, for working towards legislative reforms. No one of the things that I could offer, I think, is a silver bullet, but all of them are worth exploring.
Other questions in the room? Thank you for the discussion. My name is Michael. One thing I'm struck by is, and I walked in insight, so apologies, this is part of the framing, but is kind of the different modes of resistance, maybe we could say, and kind of the zooming in, zooming out makes it such that I could see kind of space for a bunch of different types of people who want to figure out their role in how do we deal with the courts, like what do we do about all this, which seems to be kind of like the thrust of most people's questions. So like court watching, kind of the very specific like textual thing as like one point. There's like the know your rights, like kind of community education type of approach, which maybe is taking a step back up into like media and politics and running campaigns and kind of the more macro type of approach to these things. And I'm starting to hear a little bit of like, my question was going to be about the interplay between those, and it seems like focusing only on one is kind of doomed, right, in its own way. We need to the tying it all together is like, what is our like solidarity economy, or like, you know, what is your kind of gesturing also towards like the resources and like, you know, we need the mutual aid and the childcare and the transportation so that people can do court watching and can also do all of those things. So I don't know, it's like not a well-formed question, but maybe examples or thoughts just around like the utility of creating maybe multiple modal strategies, you know, things that kind of get at multiple things at once in order to actually get at the root of the thing. Like, does that strike y'all as on the right path?
Yeah, I mean, I think this connects a little bit with the question before about the potential emptiness of like walking into a courtroom and invoking your Fourth Amendment rights. And so, to my mind, you know, there's always a hole. For example, if you go into KYR and say, "Hey, your rights are to say no," and that's the end of the conversation, right? In fact, let's say your rights are to say no, and if you need a lawyer to back you up, here's a lawyer that can back you up. Ideally, I will be that. Like that's sort of like community building where there's trust between the folks who you're interacting with, so you can keep going back and have that relationship ongoing. But once you do that, then you have to be prepared to push from the other end. Because if you don't, then the expansion of the balloon in that direction is bound to happen. So a media strategy on the other side is really important. Having buy-in to the community where you're working with and sort of working hand in glove with that community is really, really important. So to my mind, yeah, like that, what you're saying in terms of what we're doing, it's how we're thinking about it. It can't just stop at sort of just the clinical project where students are representing parents in Article 10 proceedings or the predecessor to Article 10 proceedings. There has to be sort of other community relationships that we've got that put pressure in all sorts of different directions. So I think that's how we're thinking about it for sure.
I share your intuition or sort of the idea behind your question that we need all of these things together. I don't think any one group can do all of them. So it's about coalitions and solidarity. And I also don't think there's any one right way to do it. So when I've been describing court watching, I've mostly been describing sort of groups that would use the rules of the courtroom. Like say we have a First Amendment right to be here, seek the court officer's permission, sit in the audience section, and sort of follow the rules, but through following the rules, resist what's happening. there are other ways to court watch, right? You can storm a courtroom, you can block the hallways, you can protest. And so I don't mean to say that there's also not any one way to do any of these things. And so in any large social movement, you're gonna find people organizing in all different ways, and sometimes there are conflicts, and so there are people who think really deeply about how to deal with conflicts and tactics. And so I think a lot about these different tactics, and I try to lift up certain ones like this organized court watching that I think we don't always think of as powerful forms of resistance. But it doesn't mean that anything we've said is like the answer. I mean, the answer is all of it and don't do nothing. Yeah.
Right.
So we're at time. We did have one question from online, which was how do we maintain the hope to keep doing this work in light of everything? And I'll seize my moderator's prerogative and answer the question and say that at least for me, nothing gives me hope like being around other people who are sharing in these questions in this work, like these incredible panelists. There is no substitute for solidarity. So please join with me in thanking Peter, Pete, Tarek, and Jocelyn for spending this evening with us. Thank you for being online. A small plug, if you want more on law and political economy in courts, the LPE project is partnered with the People's Parity Project and several scholars and activists from across the United States to do an online series on the federal courts. If you go to the website of the LPE project, you can get more information about the series. If you'd like to join our mailing list, we'd love to have you. Check us out at the LPE NYC LPE project, and stay tuned for the next installment of the New School LPE Night School at the New School next month. Check your inbox, Twitter, and the website for more on that in the days ahead. Thank you all.
Thanks, everybody.
Hey, Dad.